Welcome everyone to the first of the trilogy for WiCCD. This first one is going to be about complex bails and particularly murder and extradition. So we have Diana Magas from Ottawa. She's joining us from, I think she's in her office in Ottawa or somewhere in Ottawa, but going to be discussing murder and how to handle those types of complex bails. And we also have Michelle Biddulph, who works here in Toronto, and she'll be discussing extradition bails. And I know she'll probably talk about a case that she's recently done as well, which is why we called upon her, because I don't think I've known anyone who's dealt with an extradition case before. So I think what we're going to start with Diane, and then we'll end off with Michelle discussing the extradition stuff. So Diane, if you can take it away.
Yes. Thank you very much for inviting me. Just for anybody that doesn't know me, so I've been practicing in Ottawa for 28 years. And I've been involved in some murder trials in the last 15 years, I guess, before we have the practice for the first 13 years, maybe. And then, so I've actually brought some bail application on murder charges, which is something that is obviously more rare than your run-of-the-mill type of bail situation that we see every day. So I'm going to try to speak to you a bit about more of a practical issue with respect to having bringing bail application on murder charges. Obviously, because of the seriousness of the charges, most of the time, it may not even be appropriate to bring a bail application, especially if you have a client that's got a criminal record and so on. But there has been success. There's not a lot of cases, if you look for it, in out there in supporting bail pending murder charges, but there are some. So the first step is, and I think everybody should know that's so a bail application on a murder charge or even accessory after the fact of murder, anything to do with section 469 has to be brought in front of a superior court judge, and it's a reversed onus, obviously, with those type of situation. Although and that happens more often these days than it used to be. For youth offenders that are charged with murder, it is not a reversed onus situation, and there is a dual competence with respect to who can hear a bail hearing. So either a superior court judge or a provincial court judge or OCJ or different provincial court in different provinces can hear a bail hearing for a youth. In addition to that, for youth, even if the person is found to be detainable, the youth can still be released on a placement in the care of a responsible person, even in a case of a murder charge. And that has actually happened in Ottawa in the last couple of years. It was with respect to a co-accused of my client who was charged with first-degree murder. The youth, who's a female, also charged with first-degree murder, was released to be placed in the care of a responsible person under the Section 31 of the Youth Justice Act. So that is a bit of a difference for youths with respect to murder charges. There's a more recent case of R versus TJM, 2021 Supreme Court of Canada 6, that has dealt with the jurisdiction in youth matters, that has confirmed that there is dual competency or with respect to who can hear those type of hearing. And I'll refer to a few cases, and what I can do is I can give my copy of the the citations for the cases. There's a couple of cases that are not reported that if you want a copy, you can maybe reach out to Maya or Tanya and I can give them a copy of them. One issue with respect to jurisdiction vis-a-vis youth charged with murder, the Supreme Court of Canada in the TJM case left open the door as to whether or not there's competency still open for both level if the trial is already started in the Superior Court, and they decided not to make a decision on that point because it was not before them. So that's the main difference between a youth and an adult with respect to murder bail hearings. In the context of bail hearing, obviously, the main issue in a murder case is the tertiary ground. In some of the cases, there's issues of primary, secondary ground, but I think that when you have cases where you have all three grounds that are actually a problem, probably not a good idea to bring a bail application. It's probably not going to be successful because most of the cases that I've seen, it really goes to the tertiary ground. One of the cases that I've relied on in the past on murder bail is called Arvis's La Framboise. It's an Ontario Court of Appeal decision from 2005, and that decision predates St. Cloud. It actually relied on Arvis's Hall, which appeared to be a stringent test with respect to the tertiary ground. But it's still referred to often, and actually was referred to in St. Cloud by the Supreme Court of Canada. And in that particular case, it could be used in other cases than murder, but this is where Ontario Court of Appeal said that the nature of the offense charge itself cannot justify the denial of bail. So being charged with murder by itself does not justify the detention. Also said at paragraph 32 that even the strength of the Crown's case is not sufficient to justify detention on the tertiary ground. And in that sense, one which should also keep in mind in St. Cloud, although St. Cloud kind of watered down Hall, I think it's important if you're going to do a bail on the murder to refer to paragraph 50 of St. Cloud, which is agreed, and I'll just read the quote there, that I agree with the appellant that detention may be justified only in rare cases, but that is simply a consequence of the application of section 515.10c and not a precondition to its application, a criterion a court must consider in its analysis or the purpose of the provision. So it's in a way an ability to use Hall as it used to be used and no longer followed in terms of its application in only rare cases. But in St. Cloud, it still recognizes that it actually is implemented only in rare cases. So I think that is still a good paragraph to use when you have a murder case. Another case I like to use in a murder bail application or other type of serious cases is Arvis's Jaser, J-A-S-E-R. It's a more recent decision of the Ontario Court of Appeal, 2020 decision. In that particular case was a terrorist offense type of situation, and actually the accused had been convicted. It was a situation of bail pending a retrial, and at paragraph 118, the Court of Appeal found that even in cases where all four factors have been satisfied with respect to the tertiary ground, the justice has to look at the plan of release to be satisfied whether or not that satisfied the tertiary ground. And that's important, especially in a murder case, because in most of the situation in a murder case, you'll have a situation where all 4 factors are met, and then you're stuck with saying, well, notwithstanding. So that particular case is really good on a murder charge, but also in other very serious cases. There's also case law that specifically says that, you know, in some of the justices apply an improper test in terms of listing the factors to be considered, but not actually applying it. And that is also what the court in Jaser was saying, that we have to actually apply it to the facts of the case. And that is important with respect to those. I can also speak to you about a case. It's Arvis's Kublu, who was a young Inuit that was arrested a few years ago for and charged with second-degree murder in the stabbing death of her mother. And it's an Ottawa case, and this young lady, who was only 19 years old at the time, came from Nunavut and you know, had no means to meet a high bail bond, for example, was actually released on a $500 bond on a second-degree murder charge. The judge, I have the case if anybody's interested. The judge, Justice London Weinstein of Ottawa, Ontario Superior Court, released her, considering and making great law in my view, in terms of the Gladue factors to be considered in that particular case, and releasing her. It was a very structured plan, obviously. There was no electronic bracelet required, but there were residency condition, some treatment program with and different types of treatment program. Alcohol was an issue, which was intergenerational issues with respect to her particular case, and also with respect to obviously a lot of Aboriginal cases. But I find that that case in terms of releasing someone on a second-degree murder with a $500 bond is a bit of an exceptional type of situation, but it can happen. So obviously that type of situation, because of the Gladue report, and in that particular case, the Crown had argued that, you know, the fact that she could not post a substantial bail, actually did not have anyone to be a surety for her either, ought not to be released. And the judge actually found that that is essentially what why we have Gladue principles to be applied to bail, and that released her on in Ottawa. We have the Ottawa Center that sometimes act as bail supervisors. So that was the type of release with, as I indicated, a bail bed plan and some strict conditions. But it is still amazing that someone on a murder charge can be released without a surety and on a $500.
And sorry, Diane, how do you spell that case?
Kublu, Kublu. It is not reported. I checked earlier today to see if it was. It's not. I can provide you with a copy of all the cases that are not reported too, so that if anybody's interested to get a copy. I did obtain a transcript of the decision, so I can share that with everyone. But unfortunately, it's not reported. The other case that I've been involved in that it's frustrating is a case where one of my clients is charged with murder where identification is an issue. And although in my view, the Crown's case is very weak, he's not been released on bail. And what I had to do in that particular case is bring a bail review application. And then you have to look at where you go in terms of bail review in murder cases. And Section 522 of the code provides that the order is not, so it's 522 sub 4. An order made under this section is not subject to review except as provided in section 680, which then brings us to where do we go? And it depends on where, what the issues are. And just so also, you know, in terms of section 522 of the code, and in terms of what material you can have before the court, the rules in this province, at least in Ontario, I cannot talk about the other provinces, but provide the same type of material as a bail review have to be provided at a bail hearing and at a bail review itself. So that means you have to file an affidavit from your client. So, which is different than bail at first instance, where, you know, if you don't want to put your client in the box, you don't have to. In a bail murder, you have to, unless the Crown agrees that they do not want to cross-examine. So in that particular case, the Crown told me they wanted to cross-examine my client, so I had no choice but to put an affidavit from him, and there's case law on that, and he was cross-examined. And then we went for bail review, and the question then becomes, where do you go? So according to the case law from the Ontario Court of Appeal, and there's two cases on point with respect to that. So there's Arvis's AAC, Ontario Court of Appeal decision from 2015, that indicates that if the bail review reasons are for material change of circumstances only, then you go in front of a different judge of a superior court. If you want to claim or argue errors of law, you have to go in front of the Court of Appeal. And if you have mixed errors of law and material change of circumstance, then you still have to go in front of the Court of Appeal, because the judges of the Superior Court do not have authority or jurisdiction to review a decision of a fellow Superior Court judge on an error of law. So there's two cases on point in that respect, and those are Arvis's ACC, and I will give you the name of the other one. Her Majesty the Queen, or now His Majesty the King versus White with a Y, so WHYTE, which is 2014 Ontario Court of Appeal, and that was from a full panel of the Court of Appeal with respect to review under section 680 of the code. And one of the finding from the Court of Appeal that agreed that constitute a material change of circumstances is if after a preliminary inquiry, the Crown's case is seen to be weaker than originally seen, then that is enough to constitute a material change of circumstance. And that is something that is obviously important in terms of bail for a client who may have been refused at the first instance, but after a bail, after a preliminary inquiry, then it may be seen to be a weaker case. In that particular case, it dealt with, it appeared to be more an issue of manslaughter as opposed to intention, and being able to be proven by the Crown. So the court found that that was obviously a material change of circumstance that ought to be addressed by the court, and in that particular case, the accused was released. Another way I find that bail may be a good plan, even if you don't think that your client may be able to get bail, is that you see at the beginning of the case, the Crown's case at its best. Because in a murder file, I find that the Crown will take and put before the judge their best foot forward to try to convince the judge that they have a strong case. So it allows you to see the Crown's case well in advance of the prelim, and they'll put everything they can together to do that. So it is in that sense even a tool, I find, for the defense to be able to see the Crown's case in a better light, because what we get when we get a murder trial or a murder file is we get thousands of pages of disclosure and what sometimes I call a disclosure dump, and then you got to try to decipher where is the Crown's case in all of this. So one way to see it very clearly is the Crown's bail brief. Often they have a PowerPoint presentation, and then it allows us to see that. You also have to look into the fact that usually on a murder bail, you'll have multi-days of bail hearing, and the reality of defense practice is that I've not seen many murder files where the accused are able to pay the defense, and so it's usually a legal aid file, and you have to try to get that into the budget. For example, the one I did more recently was a 4-day bail hearing for a murder, so you definitely have to get that worked into the budget with your budget manager, because the bail hearing, although it's actually court days, for example, does not count for trial days. So I was able in that one to convince them to pay it and actually pay a second bail review when you can convince them there's, for example, a material change of circumstance. But you, practically speaking, because you want to get paid, it's not a regular, the 2-hour that's allowed through legal aid files, but you definitely have to try to get your budget together and work that in, because that's a lot of work to prepare. It's almost like a prelim, because they're difficult to win, and you have to think that you also have to pay for your expenses, pay for the transcript if you're going to have a bail review, and those are not covered on the usual certificate. So that has to be thought about in advance and worked on. I see that I have a few minutes left, and I was told to work in some time for questions. So I'll take some questions now if anybody has questions.
So everyone, feel free, you can either put the question in the chat. I just was putting those cases in the chat, or you can just ask directly to Diane.
Yes, I can actually put my email address in the chat too, so that anybody that wants a copy of the case law can send to.
And what we'll do, it might be easier, Diane, if we, you could send me and Maya the case law, and then we can just distribute it to everyone who has registered, so that it just might be easier instead of people reaching out, and then we can just send it to those who have registered.
That's good. And I left my email address too, if you have any questions specifically that you want to ask me. I'm quite open to do that. I am busy, but if you email me, I'll find the time to respond back to you.
Looks like Maya has a question.
Yeah, I do have a question, because I find that, and you actually mentioned, Diane, that in murder bail hearings, usually Crowns have PowerPoint presentations. They also have these big case books with tons of cases. And sometimes I find like it does kind of, I don't know what the right word is, maybe intimidate the, like whoever is hearing the case. And what do you do? Do you also prepare a PowerPoint presentation, like to bring that as opposed to what the Crown is doing, the show that they're putting on?
Yes, I'm not too much of a PowerPoint person myself. I speak very loud, no, and I intimidate that way. But I think I focus more on a few cases. I find that the judges, if you bring too many cases, they get lost in it. So you got to find. That's why I mentioned a few key cases here that are strong words from strong judges that you use. But especially for murder trial, I find that you have to show the judge, you have to convince the judge that it's not an open and shut case for the Crown. If the judge thinks it is, you're probably not going to get bail like at all, because it's murder, right? So it's difficult to convince anyone, especially on the tertiary ground. So you got to poke some holes onto the Crown's case, and that's where you get to do that, and you get to also get to see their case in advance, which is good practice for the trial, right? So even if you can't win on the bail, you can at least see a lot in advance the Crown's main argument, and that's always good. But I think for me, I don't like, if anybody uses PowerPoint, sometimes I find the judges get lost in the PowerPoint too, because it's gets a bit boring. But it's in this day and age with video surveillance, with imaging, I also found that some of the video imaging, you have to be careful with what the Crown does with them and what it actually depicts. In one of my cases, they were trying to say that we can see moles on the person that are similar to that of my client. And then when I spoke to the expert, he indicated that may not be mole, that may be other things in the video itself, and so on. So that's a good tool for that purpose, to be able to poke holes at the Crown's case. But I think that's what you have to do to convince the judge, in my view, is that it's not an open and shut case. And because for us, the power presentation, we're not presenting a case, right? Like, we're just essentially presenting our plan, which usually has to be like, there was the unusual case with the young Inuit girl, but other than that, it's GPS, sureties, 24 hours, direct supervision by sureties and so on. So there's not really a need for a PowerPoint for that, I think.
Okay. So thank you, Diane. That was very informative. So now we'll start with Michelle, who is going to discuss with us about extradition bails, which are going to be, I think, tough at least, but Michelle's here to work us through it.
Yeah, if you think murder bails are tough, wait till we get into extradition. So for those of you who don't know me, my name is Michelle Biddulph. I'm a lawyer at Greenspan Humphrey Weinstein in Toronto. It's a firm that does a lot of extradition work, so I've have some experience with extradition bails, although I told Tanya when she asked me to do this that the only contested one I ever actually ran, I lost horribly all the way through. So as long as that doesn't disqualify me, I'm happy to speak to you guys about it. So apropos actually of Maya's question about PowerPoint, I did prepare a PowerPoint presentation because I needed it to keep myself on track. So I'm gonna share my screen. There we go. Okay, and let's get going. There we go. Okay, so for those of you who haven't dealt with extradition matters before, the way it works, I guess there's two types of extradition bails. There's bail where some other country is seeking the extradition of your client, so it's bail pending extradition. Or there's bail where some other country is sending their client to Canada to be tried here. So that's bail pending trial, but on an extradition. I'm only going to be talking about the first one because, if your client arrives in Canada to be tried in Canada, the bail principles are just normal trial bail principles. The only thing you really have to look out for with those kinds of bails is that generally your client's not resident in Canada, so you need like a cash bail or extra sureties or things like that. There's going to be bigger primary ground concerns. But I'm going to focus on bail pending extradition to a foreign state. So the way that works is Canada will receive one of two requests from the foreign state, either an extradition request, so saying, here's our record of the case, send us this person so we can try them, or what's called a request for a provisional warrant, which is, we've issued a warrant for this person's arrest. We think they're going to flee. We need you to arrest them right now. We'll send you the record of the case later. So it'll be one of those two. The International Assistance Group in Ottawa, which is a branch of DOJ, they review it, tell the minister what to do. Minister invariably says, proceed. And so the minister issues what's called an authority to proceed or authorizes the AG to apply for an arrest warrant. Either way, your person gets arrested and the bail process begins. So if you've got a provisional arrest warrant case, the case that I was talking about that I lost all the way through was the Peter Nygaard extradition. So this was a provisional arrest warrant case. So in this case, the United States sought a provisional arrest warrant. The minister said yes. And so the AG applied on an ex parte basis to get this arrest warrant. In order to do that, they have to show the judge that there are reasonable grounds to believe that it's necessary in the public interest to arrest the person to prevent them from escaping or committing another offense. This may become problematic later once you get to the bail stage. But if they convince the judge of that, then the warrant's issued and your client is arrested. The other way is through an authority to proceed. This is essentially the extradition version of an information. So the information is sworn, the authority to proceed is issued. The authority to proceed will list whatever the Canadian equivalent offense is of what your client is being extradited for. So imagine, they're charged with some kind of trafficking in the US. The authority to proceed will say the equivalent Canadian offense is trafficking in a Schedule 1 substance, whatever. And so that's what is used to frame the bail hearing, to frame the committal hearing, and to frame things all the way through. So all of this is very nice, but I'm here to talk to you about what to do. I also would like to just admire this picture for a moment. I was looking, for some reason I wanted a picture of like the Hamburglar behind bars. I couldn't find it, but I found this, which I don't know about you guys, but do you remember just like the fever dream that was McDonald's characters in the 1990s? This is apparently Officer Big Mac, and this was a little jail for children. Yes. So very funny. Anyway, if your client gets arrested, like anybody, they have to be brought before a justice within 24 hours. But like a murder bail, an extradition bail can only be dealt with by a superior court judge. So what that means is that if they're brought before a JP or a provincial court judge, congratulations, they're getting detained because they have no jurisdiction to release this person. There's also very special rules that apply if it's the International Criminal Court that is requesting the extradition. And congratulations if any of you get one of those cases, because I don't think there's ever been one in Canada. So I don't know the rules and I'm not going to explain them. But once we get to the actual bail hearing, extradition bails, there's no special rules in the Extradition Act. It basically says Part 16 of the Criminal Code applies with appropriate modifications. So like I just said, murder bails are only heard by a superior court judge. But I've listed some issues to watch out for when you're doing these extradition bails, and I'll go through each of them. So the first is, are you dealing with a provisional arrest warrant bail or a bail on an authority to proceed? If you've got a provisional arrest warrant bail, you have to make sure that you get disclosure of the materials that were submitted to the justice to issue the warrant. And the reason why is because imagine the Crown argument on this bail saying, well, a justice was convinced that he was a danger of fleeing. There were reasonable grounds to believe he was going to flee or he was going to commit another offense. How can you possibly go against what this justice said? So you need to see what was before that justice in order to counter that argument. Generally, this doesn't have to be a disclosure request because the AG will usually submit it in the bail hearing as part of, an affidavit from someone in their office or something like that. But you just have to make sure you have that material. And then the other way, if it's an ATP case, there will be what's called the record of the case, which is like all of the evidence of the requesting state, the state that's requesting the extradition. It's like a summary of all of the evidence and allegations against them. But if you've got no record of the case, then the Crown basically puts in whatever it wants in the bail record. There's going to be things called bail letters, which I will go through, the provisional arrest documents, and then whatever other documents the requesting state decides to create, like an indictment, for example. So this is the most unreliable evidence you can imagine, and it's impossible to challenge. And I'll show you an example. So I went through this multiple times. There is no 517 publication ban on this, but I redacted it anyway, just because I'm terrified. So the redactions are just things that identify the client. You can all guess who the client is. So this is an example of what a bail letter is. These are things that are submitted by the prosecutor in the requesting state, essentially saying, hey, judge, this is why I think you should detain this person. Here's my opinion. So you can see, here they say at the bottom there, blank should be detained because, as outlined below, he presents a danger to the community, a flight risk, and the evidence against him is strong. There were a bunch of allegations in this bail letter that the client had obstructed justice. He interfered with witnesses. He was never charged with obstruction of justice in the United States. If they had all this evidence, why didn't they charge him? They just put it all in the bail letter and, let these prejudicial allegations go against him. They would make assertions of fact with no support about, him hiding his wealth in all these different areas. They commented on the materials that were submitted by the accused in the bail hearing, saying, don't believe this surety. This guy's lying in his affidavit. Watch out for this. Very offensive stuff. But fortunately for us, it was all accepted by the judge. This quote comes from the Manitoba Court of Appeal for the bail review. After we had tried to challenge the admissibility of all this prejudicial stuff in the bail letters, saying, well, sorry, the bail letter outlines these concerns about interfering with witnesses, so of course he should have been detained on the secondary ground. It's very frustrating, and these are most common, at least from what I've seen, in cases where you've got a provisional arrest warrant rather than a record of the case. So you've got bail letters, what can you do about it? You can't require the author to testify because it's not sworn evidence, it's just opinion. And also they're in a foreign state. Maybe you can challenge the admissibility. There's cases going both ways in Ontario. There's the Manitoba Court of Appeal saying, no, sorry, it's admissible. Sorry, everybody. And then the BC Supreme Court in the Mung case also ruled this was admissible. But you can argue that these types of letters are pure opinion and argument. It's essentially submissions of a lawyer. So it should be entitled to little weight. It's not evidence for the truth of its contents, it's just opinion. And so there are two cases that I've listed here, and both of these come to that conclusion. So if you end up in this situation and you're dealing with bail letters, this I think is the best argument to make, which is just that their opinion, give them little weight. Sure, they're admissible, but they're not evidence. Okay, I already gone through all of this, which is just in an ATP bail, you will have the record of the case. It gets a little more difficult in challenging the substantive reliability of what the requesting state is putting forward to substantiate any primary or secondary ground concerns. And that's because the Extradition Act deems the record of the case to be reliable evidence. So pretty difficult to make a reliability challenge. It's basically, the best I could come up with is you treat it like the synopsis is in any bail hearing. You have to, presume it to be true, but there's ways you can poke at it. So now going through some other issues in extradition bails. The one that's was most surprising to me was that the right to reasonable bail doesn't apply in extradition. This comes from the Schmidt case in 1987 from the Supreme Court, where Justice Laforet ruled that Section 11 of the Charter doesn't apply to charges laid by foreign states. He tried to throw us a bone and say, well, maybe there's some right to reasonable bail that's contained in Section 7, but didn't really expand beyond that. And as far as I can tell, no one's really looked at that since 1987. So what that means for us as defense counsel is that we don't get to start from the same constitutional premises, the same constitutional premise that we do in domestic bails. You can't start from the premise that this person has a constitutional right to reasonable bail, because that's just not true. Maybe you can argue there's some kind of residual right in Section 7, but no one's looked at what that means in the context of Section 515. So it makes the argument harder on extradition bails. There's also an issue with onus. The Extradition Act doesn't say who has the onus in an extradition bail. From what I can tell, courts basically say, well, whatever charge is listed in the ATP, so whatever charge is the Canadian equivalent of that for which extradition is being sought, if that charge is a reverse onus offense, then it's a reverse onus bail. So what that effectively means, the minister decides what charge is listed in the ATP. So the minister gets to decide whether this is going to be a reverse onus bail or not. Did I tell you these things are unfair? But there's also, you know, if your client's not resident, it's reverse onus because of that. So basically, you don't really know the onus until you see the ATP, or it's reverse onus if your client isn't ordinarily resident in Canada. Now, primary and secondary ground concerns. The typical concerns on an extradition bail will be primary ground concerns. And that's just because I guess people have incentive to flee in order to avoid extradition to another state. I'm not sure, but that seems to be the thing that Crowns are most often concerned about in extradition bails. But secondary ground concerns, we get into some unfairness here. So I have an excerpt here from one of my favorite cases to submit on any bail, which is a decision of Justice Durno in Downey. And that's where he's talking about the use of occurrence reports and things like that by the Crown in a bail hearing. He basically says these things are unreliable, they're bald hearsay, they're completely irrelevant, and the Crown should not be submitting them. Which is great, I love it in domestic bails, but doesn't really apply in extradition bails. And that's because there's a presumption of reliability for the material submitted by the requesting state. There's also this fun little line in this BC Court of Appeal decision, which has been followed virtually everywhere, saying that for extradition bails, you have to look at the primary ground much more strictly than you would in a domestic bail in order to honor Canada's international treaty obligations. I'm still not entirely sure what that means, but it basically means it's a higher standard for release on the primary ground in an extradition bail than it is in a domestic. And now we get to the fun part. So you heard Diane talking about the tertiary ground in murder bails. Guess what is a very, very difficult ground in extradition bails? That's the tertiary ground, and I'm going to take you through why. So we all know the tertiary ground, the 4 factors that you have to consider: strength of the prosecution's case, gravity of the offense, circumstances, and potential for a lengthy term of imprisonment. These all apply in the extradition context, but with some little extradition twists. So the first one, when you're looking at the strength of the Crown's case, the vast majority of the case law says that you have to look at it as the strength of the Crown's case for committal, not the strength of the Crown's case at trial. So standard for committal is extremely low. It's the same as the standard for committal after a preliminary hearing or the standard on a directed verdict, which is essentially there just has to be some evidence. It doesn't even have to be that believable, just some evidence on each element of the offense. I mean, you can have a case with no reasonable prospect of conviction whatsoever that gets past this standard. So it essentially means that this factor always, always, always weighs in favor of detention in an extradition case. When you're looking at gravity of the offense, just by virtue of the way the Extradition Act works, extradition is only available for offenses carrying a maximum sentence of 2 years or more. So automatically, extradition is only available for grave offenses. So again, just because of the nature of extradition, this will always weigh in favor of detention. Circumstances of the offense, that one's the same. And then liable to a lengthy term of imprisonment. So this is a fun one. Instead of looking at, you know, the domestic offense in the ATP, okay, what would be the term of imprisonment they would get if convicted in Canada? No, when you're applying this in the extradition context, you have to look at what term of imprisonment they might get in the requesting state. So guess where most of Canada's extraditions go to? It's the United States. You're going to have clients for whom they're looking at mandatory minimums of 30 years or more for things that might get them 90 days in Canada. I lost an extradition on that, and I'm still pretty mad about it. But the point being that this too will always, at least when you're dealing with US-based extraditions, will always weigh in favor of detention. So in effect, everybody should be detained on the tertiary ground in extradition cases. And this was the argument we tried to make when we sought leave on the Nygaard case. We wanted to argue that there should be a right to reasonable bail in extradition cases, and Section 515 sub 10 sub C of the criminal code has to be interpreted in a manner that doesn't result in differential treatment for people just based on the place in which they are charged. Supreme Court denied us leave, probably because our client was, the poster child for the tertiary ground, but that means it's still open. So somebody please has to litigate this. Just as a practical matter, if you lose your bail hearing, your bail review goes to a single judge of the Court of Appeal. I think that's the same as for murder bails. If you win, so the way an extradition works, there's the committal phase, which is before a judge. Judge says, okay, there's enough evidence to commit. Once your client's committed for extradition, then the matter goes to the minister. This is the surrender phase. So you need to bring another bail application pending the decision of the minister. Normally, if your client was on bail, this is going to be on consent, but just to flag, you will have to do it again. And then if your client is surrendered, which happens virtually every time, and you want to appeal either the committal order or judicially review the minister's decision, you have to take a bail pending appeal. So that's just decided on the bail pending appeal standard. So in summary, extradition bails are incredibly difficult and incredibly unfair. You will, of course, have lots of crowns who consent. A lot of these rants come out of, the one contested case that I did. I have seen plenty of cases where the crown consents to the bail. But if you have a contested extradition bail, fight it. Fight the reliance on these unreliable bail letters. Fight the unfair application of the tertiary ground. This is not how our law should work. If you've got a sympathetic client who ends up getting detained on the tertiary ground, then perhaps consider a charter challenge to the tertiary ground itself. I mean, that's essentially what happened in Antic, although that was about, I think, cash bail, but they did it as a charter challenge. So why not do the same here for an extradition bail? And maybe we could read down the stupid tertiary ground, which is probably my least favorite provision in the entire criminal code. But what we need to do is we have to fight for a constitutional right to reasonable bail for all Canadians, regardless of where they are charged. And right now we don't have that. So I believe, yes, that is the end of my presentation. Happy to answer any questions. Otherwise, thank you for listening.
Yeah, thanks so much, Michelle. That was really great with the PowerPoint and everything. And I understand that basically don't get in trouble or I won't get bail. So does anyone have any questions for Michelle about extradition bails? And you could also write it in the chat too if you don't want to call out.
I'm going to ask a question or a comment, but I think it's time someone challenged constitutionally the fact that the charter does not apply to a Canadian resident that's maybe charged abroad. Like nobody's challenged that before.
So it's interesting. There are parts of the charter that do apply. So Section 7 does apply. The problem is that the way it applies in extradition is extremely deferential to the requesting state. So for example, the case I was talking about where we had, the 90-day sentence in Ontario and 30 years in Minnesota, we brought a constitutional challenge to that under Section 7 to basically say it would shock the Canadian conscience to extradite this guy to 30 years when he would get 3 months in Canada. But the law is so horrible in that we lost. The Court of Appeal said, no, it doesn't shock the conscience, it's fine. Basically, only the death penalty would. So, I mean, there are charter rights that do apply. There's Section 7. There's also Section 6, which is the right to remain in Canada. The way that applies in extradition is that Canada always has to be given the opportunity to prosecute first. If you've got an offense like a fraud or something that has cross-border implications, Section 6 of the charter says Canada gets to go first if they want to. But otherwise, we don't really have a ton of charter rights in extradition.
So I just had a question about that because you said that it's only the death penalty that would shock but here's the thing. But if I'm 40 and the sentence is 30 years, is that not death? Like you're going to die in jail? Because even going to jail takes off. Like I think there's studies done that say for every year of your life, like 2 years, if you're spending in jail are like taken off your life, and generally you die of so is that not an I guess it's more of like a weird question.
It makes perfect sense to me. I know there was a case where this was argued. I can't remember off the top of my head what it was called, but it was a drug case where the guy was facing like 30 or 40 years in the US. And that was the argument made, was he's going to die in prison there. And which I think it was not the Ontario or the BC Court of Appeal, probably Ontario, they're less sympathetic. But I think they said basically, well, he'd get a long sentence here too. So sorry, it doesn't shock the conscience.
Huh. Okay. And does anybody else have any questions? I find this area actually really interesting. I should have bought the extradition book from Iman. Well, I guess where's Maya? Is she there? So yeah, no, that was really helpful. And both is Diane still there? Yeah, she's still there. Both thank you both for making your presentations. I know both of those areas are like super complex. I've never done a murder bail or extradition. And I'm sure many of you probably haven't either, but I think that this is all really good information to keep in the back of our minds for in case one day we get one of those interesting bails that we have to deal with these types of issues. And I'm sure we have Diane and Michelle, people that possibly, both of them are probably very busy, but we can still maybe email for any sort of assistance or any questions that we have. So yeah, thank you so much, guys. That was great.
And this session is being recorded, so we will be circulating a copy of it to all the members who registered for the session. I did receive, Diane, your email with the cases that you mentioned. Thank you very much. And we will also send that by email. I guess, Michelle, I don't know, we didn't confirm with you if you will be sharing with us the PowerPoint presentation, but if so, we will do that as well.
Yes, I'd be happy to.
Thank you very much. If there are, let me just see here if there are questions in the chat. Oh, it's just comments. But it was a very good session. Thank you very much, ladies, both of you. Just like Tanya said, you're both very busy. I know Diane is always in a murder trial, so it's very nice that she was able to make time for us tonight. So if there are no questions, yeah, no, thank you very much. No, I don't see any questions.
Yeah, and thanks a lot, Michelle, for coming. I was like, I know Michelle's busy as well, so I was like, let me try. And I'm like, extradition. I'm like, I know exactly the person.
I really appreciate it. It was lovely. Thank you so much.
Can you guys hear me?
Yes,
Yes, Anita.
It's important for this part to be part of the recording, I think. Did you remember to take a group photo? It's all I care about. You want me to take it? I won't show my face because I've had a long day of your team here, but may I take a group photo?
Yeah, sure. And if everyone feels comfortable.
You can put your videos.
You can decide if you want to say extradition. I have to close the chat first to take a proper photo. Okay, everybody say, what do you want to say?
I like murder.
One's overcognizance, you want to say murder? Okay. Yeah. Okay, 1, 2, 3, murder. Okay, I'll take another one. Just hang on, I have to perfect this and slide the other picture. Okay, 1, 2, 3. Hey, Naomi, look at the camera, my girl. Okay. All right, calling her out. Okay, 1, 2, 3. Excellent. Beautiful. Thank you so much. Okay, now I have something to, well, everybody else could have, but chose not to turn on their video, and we appreciate that. That's okay. That's a beautiful photo. Thank you so much. And thank you. That was a really excellent session.
Perfect.
Fantastic. Thank you.
And someone asked, wait, printing the chat and sending to participants. I printed a chat.
So if you transcribe, is transcription on?
I think so.
It has enabled closed captioning.
Yeah, closed captioning.
Yeah, sometimes you can save the chat.
Wow.
Huh.
That's terrifying.
Yeah.
Well, just because the text,
yes, I can. It says save chat.
Wow. Where does it say that?
There's right by where you're typing messages, there's a three dots by the smiley face.
Holy cow.
I didn't know you could do that.
I didn't know you could do that either. I'm gonna watch myself, and this chat is fine. This is just me going like, well done, ladies. But I I didn't know anyone could save a chat. That's not good news.
I'm gonna no one else wrote anything. I'm the one who was writing really. So I saved it. Hopefully, yeah, I saved it in my documents here. So hopefully that's fine.
For the case
And
sites,
just-
that'll be really helpful.
So for whoever wanted, when Tanya was writing about the cases I was referring to, those I sent to Maya and Tanya, and I think they're gonna share them. So if you
Yes.
don't have them from
Okay.
the chat, you'll have them.
Okay. Thank
Yeah.
you.
Yeah, so that's perfect so that we have those.
Yes.
Okay. All right. Thanks so much, guys. And thank you again to Diane and Michelle for assisting us. It was really great.
Thank you.
Thank you.
Okay.
Have a good evening.
Thank you, everyone.
Good night.
Okay, bye.
Bye.
Congratulations, ladies. Thank you.